Good evening, ladies and gentlemen. Good evening. Can you please stand as we welcome the procession inside the venue? Thank you. Thank you. Please be seated.
Goeienaand. Good evening, Moweni. It is a great pleasure to welcome you at this inaugural lecture of our colleague, Professor Anél du Plessis. In particular, I would like to welcome Professor Sibu Moyo, our Deputy Vice-Chancellor for Research, Postgraduate Studies and Innovation, trustees from our SU Faculty of Law Trust, colleagues from other faculties and universities, and in particular NWU, UCT and UWC, colleagues, friends and students from our faculty, as well as some SRC representatives, and of course our online audience. But in particular, and especially, welcome to our honorary guest of the evening, Professor Anél du Plessis and her family. I want to start off by welcoming her husband, Marius, and her children, who are also here, Christophe and Georg. I want to welcome her parents, Philip and Elise du Plessis, her brother and sister-in-law, Thijs and Elsebie Gronier, and also Anel's very close friends who traveled to Stellenbosch for this occasion, Imke Creer, Imke Vos, and Piet van der Rooyen. You are very welcome. Professor du Plessis joined our faculty as the inaugural incumbent of the SU Faculty of Law Trust Chair in Urban Law and Sustainability Governance, and that was in July of 2023. I want to say something about the person and the occasion before I will give the stage to Professor du Plessis. Professor Anél du Plessis completed her law education at Northwest University, where after she joined that institution's teaching staff in 2005. She was promoted to full professor in 2012. In 2018, she became the first to head up the NRF Saatchi Chair in Cities, Law and Sustainability. Her research and teaching center on the intersection of environmental and climate change law and governance and the legally relevant dynamics of formal and informal urban development and spatial justice. During her academic career, Anél has received many fellowships, scholarships, and grants, and she currently serves as co-rapporteur of the International Law Association's Committee on Urbanization and International Law, and she is also a founding member of the African chapter of the International Association of Urban Law Scholars. To summarize, Professor du Plessis is a very skilled and experienced postgraduate supervisor, having supervised 17 doctoral and 37 master's students, with a further 8 currently under her wing. She's a good lecturer, a prolific researcher, someone with excellent national and international networks, and a proven track record of mentorship of postdoctoral fellows, younger colleagues, and postgraduate students. Seeing that you have the biographical sketch in the flyer, her remarkable record of postgraduate supervision and collaborative research present me the opportunity to briefly reflect on academic citizenship, an often used but seldom explained term. In the literature, academic citizenship is traditionally defined as the service that academics carry out to benefit higher education institutions, the scientific community, and the wider society. Academic citizenship is sometimes seen as referring to all those activities outside of the functions of teaching and research. This perspective is based on the notion of service as academic citizenship, and it derives from a perspective that sees engagement in academic citizenship as a responsibility and a form of organizational citizenship behavior. In other words, something which is discretionary and voluntary action that falls outside of the formal job description. In a performance-driven and resource-scarce environment like the higher education sector, tension is then unavoidable. However, when academic citizenship is seen and approached as a practice of enactment, the different dimensions of academic work is seen as a whole, by the values, processes, and means by which it is enacted and asserted as academics draw from freedoms, autonomy, and individual motivation. As such, the academic becomes someone who imparts wisdom to and share knowledge with less experienced colleagues or a student. By sharing their knowledge, experience, and wisdom, academics contribute to the development of specialization fields as well as future leaders. Professor Anél du Plessis serves as an example of academic excellence and someone who enacts academic citizenship. We are excited about her future impact on her discipline and on the lives and careers of others here in Stellenbosch and in the wider society. Now, this occasion, the inaugural lecture, gives the faculty and the university the opportunity to recognize the status and the expertise of a new senior colleague who have joined our faculty. But it's also an opportunity for the scholar, for Professor du Plessis, to showcase something of her academic accomplishments and, of course, to share this professional milestone with a wide-ranging audience that includes her family, friends, students, and colleagues. Our faculty is therefore very pleased that we have the second inaugural lecture of the year that can commence, and I now invite Professor du Plessis to deliver her lecture, Divining the Impact of Climate Change on the Future of Urban Law in South Africa.
Thank you, Professor Smith. Good evening, ladies and gentlemen. So urbanization is a defining megatrend of the 21st century. Over half of the global population already lives in cities, and this ratio is expected to rise to 67% by the year 2050. The rapid rate of urbanization in Africa raises challenges and questions that are legally relevant. And these are complex because cities and towns are spaces of cohabitation where law, quasi-law, and lawlessness all converge to steer relationships between a diversity of people as well as between people and things. Cities are also characterized by head-on collisions between people's rights and by societal ills that emerge because of the proximity in which thousands, sometimes millions, of people live. In an era of planetary urbanism, cities are often ruled not so much by democratic order as by politics, trade, and investment. Coupled with the influential clustering of property ownership, wealth, and advantageous access to otherwise obscured information and novel technologies. As a manifestation of legal geography, urban law determines the trajectories of social and environmental justice. As the law of and in cities, urban law is firmly rooted in an intricate mix of public, private, and mercantile law, and has a plethora of sources of authority and origin. In the South African context, it comprises more than orthodox local government law. Since our constitutional transition, urban law is at least partially co-produced by national, provincial, and local authorities. Laws from this combination of sources determine whether and how decisions about every day are being made and accounted for. These decisions range from the rezoning of agricultural land to residential plots, the construction of a new municipal road, a bridge, or a solar farm, the installation of surveillance cameras in the CBD, or the upgrading of a taxi rank, to more strategic decisions about service delivery protests, local cultural heritage protection, the promotion of emerging creative industries, the eviction of people who settle on Dolomite land, the expansion of public-private partnerships or measures to prepare for unemployment in a town facing divestment from mining. It is therefore understandable that over the years, questions of urban law have been at the heart of many court challenges involving metropolitan, medium-sized, and small municipalities. Aspects of urban law feed into public finance management and municipal revenue raising, local economic development, and the financial sustainability of local market economies. This said, the deeply economic embeddedness of urban law often dances in the shadow of the legal discourse around the human rights impacts of failing service delivery, the collapse of municipal infrastructure, and an overall decline in voters' confidence in municipal councils. In turn, the efficacy of city governance is deliberated with reference to the ongoing decentralization project across Africa and the challenging application of the principle of subsidiarity. Urban law in this country, as is true for the rest of our continent, further concerns new types of legally relevant relationships that are emerging from informality. More than a quarter of people living in our cities reside in informal settlements and live lives dependent on informal trade, informal transport, informal labor, and informal land markets. The significance of this lies in the pertinent link between informality and the vulnerability of women, children, older persons, persons with disabilities, and persons living with chronic disease. The critical path dependencies between urban centers and their rural hinterlands also feature in urban law when one thinks of the infrastructure sustaining the nexus between water, food, and energy. As the name suggests, urban law helps direct town and city governance and is interested in understanding the legitimacy of emerging forms of collaborative governance between public and private institutions, as well as among local communities and NGOs that are increasingly dependent on their own initiative and resources to see that basic municipal services are provided and that critical public infrastructure is maintained. By now, it should be evident that urban law is a dense, hybrid area of law and that it just may be easier to ask, so what is urban law not? Yet, it is my hope that this introduction shows that on the one hand, urban law is about law in action, but on the other, it is about conceptualizing, theorizing, and re-envisioning the role of law in a fast urbanizing society. Then, the fact that cities in South Africa find themselves in the eye of a storm brought about by a global climate crisis adds an entirely new dimension of complexity. This lecture reflects on how climate change is expected to influence the future of urban law in South Africa, not only as a matter of legal practice, but also as a field of research and teaching, and I wish to focus on three main questions. The first, what does climate change have to do with law and with urban law specifically? Secondly, what is the relevance of climate change for the future development of urban law in South Africa? And thirdly, what is the role of a professor of law and the role of us, members of society, in the future development of urban law amidst a global climate crisis? So what does climate change have to do with the law and with urban law specifically? Since the 1990s, scientific research on climate change has expanded across disciplines. Assessment reports published by the Intergovernmental Panel on Climate Change, the IPCC, regularly summarize scientific findings and provide insights into causal relations, historic scientific data, and modeling. And some of the world's best scientists participate in the IPCC's work. Over the years, climate change science has evolved from early suspicions. Some of you will recall those years of fear-raising about the causes and impacts of the hole in the ozone layer, to a robust understanding of the effect of greenhouse gases and human misbehavior on our planet's climate. Today we know that air pollution is not necessarily synonymous with climate change, and that there are important distinctions between weather and climate. Climate change refers to longer-term changes in the Earth's atmosphere over extended periods of time. We also know that the complex interaction between factors in the Earth's climate makes extreme weather events, both hot and cold, more unpredictable and impactful. The history of climate change law is fascinating. The first World Climate Conference was held in Geneva in the same year that I was born. By 1990, at the second Global Climate Conference, calls went up for a global treaty on climate change, and by 1994, the United Nations Framework Convention on Climate Change had entered into force. 3 years later, the Kyoto Protocol was adopted and the Marrakesh Accord with its implementation rules shortly thereafter. Other outcomes followed from negotiation tables in Copenhagen, Cancun, Durban, and Doha, but it was only in 2015 that the much-anticipated Paris Climate Agreement was finally adopted by 196 countries, and it came into force in November 2016. The Paris Agreement is a legally binding international treaty and seeks to keep the global temperature rise this century to well below 2 degrees Celsius. The agreement establishes a framework for financial, technical, and capacity support for countries in need. It further operates on a 5-year cycle of increasingly ambitious climate action. In other words, the duties placed on countries intensify in 5-year cycles. Countries submit so-called nationally determined contributions, or NDCs, every 5 years, which outline their national actions to reduce greenhouse gas emissions and to build resilience to climate impacts. Each NDC should reflect greater ambition than the country's previous version of its NDC. South Africa submitted its first NDC in 2016 and an updated version in 2021. Our updated NDC commits this country to a 31% greenhouse gas emissions reduction with specific targets set for 2025 and 2030. Initially, international climate change law did what international law ordinarily does. It focused on interstate relations and state actors. Gradually, it transpired that the ordinary international law machinery was failing, considering the urgent need for climate action. And so today, Article 7 and 11 of the Paris Climate Agreement explicitly acknowledges the role of sub-national authorities, such as municipalities. In fact, cities now feature prominently on the international climate agenda in their capacity as atypical non-state actors. The reason for this is that on the one hand, cities significantly contribute to climate change. Think vehicle emissions, industrial pollution, the clearing of indigenous vegetation for development, the carbon footprint of construction, etc. But on the other hand, sudden or slow onset weather events that can be attributed to climate change hit people living in cities often the hardest. local government is also the first line of defense against weather events disrupting community safety, health, and well-being. The recent devastating storm in Stellenbosch and its surrounds being a good case in point. The international discourse on the role of cities in climate change law has gained momentum at incredible speed. I will highlight only 4 of the most recent developments. 1, the United Nations Sustainable Development Goals adopted in 2015 included for the first time a global goal devoted to cities and localities, SDG 11. It specifically mentions resilience and sustainability and the impacts and causes of climate change. This influential agenda also includes a goal on climate action, SDG 13, that specifically mentions local communities. 2, there's a growing number of transnational city networks, voluntary international clubs of municipalities, focusing on climate mitigation and adaptation programs. And these networks play a leading role in international climate change institutions and are visibly involved in the ongoing negotiation of the international treaty to ban plastic pollution, for example. It is worth mentioning that a handful of South African municipalities are quite active in this transnational network space, and several South Africans have been elected to serve in leadership positions over the years. 3, less than a month ago, from 16 to 19 April, over 140 experts from 65 countries met in Riga, Latvia, to draft the outline of the IPCC's first ever special report on climate change and cities. The report is scheduled to be released in early 2027, and will be the only special report that the IPCC produces in its 7th assessment cycle. This will also be one of the most focused special reports the IPCC has ever published. And notably, it is reports like these that inform future climate change law reform at the international level. And 4, as the Paris Agreement is being implemented, global attention is fast shifting to climate finance and supporting legal architectures. There is a recognition among the UNFCCC, the World Bank, the World Economic Forum, and others that no single source of finance can meet all the needs of cities, and that's not only in Africa. They are trying to establish ways of accessing and using a mix of domestic sources of climate finance, including green bonds, subsidies, and national climate funds, as well as international sources of climate finance, such as investments, to maintain and upgrade electricity and water services infrastructure, and to pilot carbon-neutral municipal projects, for example. It is, however, not only international law that is focusing on cities. Several individual countries have already developed national climate change legislation. One of the first to have adopted a National Climate Change Act was the United Kingdom in 2008. On the African continent, Kenya was the first to pass a national climate change law in 2016. And after 6 years of deliberation and engagement, South Africa's climate change bill is now only a presidential signature away, does that sound familiar, from becoming enforceable law. Adopted by the National Council of Provinces on 25 April this year, the Climate Change Bill is our first piece of legislation specifically aimed at addressing the effects and impacts of climate change. It complements the Air Quality Act's National Greenhouse Gas Emissions Reporting Regulations of 2017 and the Carbon Tax Act that came into force in 2019. As far as municipalities are concerned, it is noticeable that our soon-to-be enacted Climate Change Bill devotes an entire chapter to local government and our provinces. In terms of the bill, all metropolitan and district municipalities will have 2 years to establish a district-level municipal forum on climate change and to separately develop a municipal climate change needs and response assessment, as well as a climate change response implementation plan. While the bill states that these municipal plans should be based on, and I quote, the best available science, evidence, and information, end the quote, no mention is made of what it suggests for the division of governing authority or the budgetary implications these plans will inevitably have. Considering that climate change response action traverses many of the functional areas of legislative and executive competence of national, provincial, and local government, it is expected that the crafting and success of these plans is going to be an important test for cooperative government. As the lawyers in this room would expect, the rollout of international and domestic climate change law caused a flurry of climate change litigation. By the end of last year, the Global Climate Litigation Database of the Sabine Center for Climate Change Law had recorded more than 2,300 cases worldwide, up from 884 in 2017. Climate litigation has become a field of study on its own. The legal bases for our action range from common law, the law of delict in particular, human rights law, constitutional law, and indigenous law, to the statutory duties embodied in environmental law, administrative law, consumer protection law, company law, criminal law, and migration law. Whilst an exact definition of climate change litigation remains elusive, we see that globally, cities are typically involved in retrospective compensation cases and forward-looking cases involving the protection of their powers to govern, cases against fossil fuel companies, and litigation against their own national authorities' approval of carbon-intensive projects such as the expansion of airports. Of South Africa's 10 climate change cases to date, 5 decided, 5 pending, 2 directly involved municipalities. These were the cases of the City of Cape Town versus the National Energy Regulator of South Africa and the Minister of Energy, and the Philippi Horticultural Area Food and Farming Campaign versus the MEC for Local Government, Environmental Affairs and Development Planning of the Western Cape. The first matter, decided in 2020, concerned the question whether the City of Cape Town needs consent from the Minister of Energy to approve the purchase of solar and wind power from an independent power producer. In the second matter, which was decided in the same year, the High Court remanded an administrative decision to approve urban development affecting a local aquifer with instructions to the City of Cape Town and the Western Cape provincial government to consider possible climate change impacts such as water scarcity more fully. Admittedly, our courts have also dealt with many other local government cases in the past 30 years that may be labeled as climate aligned. Cases such as Abbott versus Oeverstrand Municipality, Masibuku versus the City of Johannesburg, Propshaft versus Ekurhuleni, and Lucier versus eThekwini Municipality come to mind. These cases showed that when the Constitution is unclear on the division of governing authority vis-à-vis the functional demands of natural resource protection, conflict inevitably arises. So what's the relevance of this for the future development of urban law in South Africa? Our cities and towns contribute to climate change, but more than anything else, they are on the receiving end of impacts most likely to be attributable to climate change. Recent weather events include the 1 in 400-year drought between 2015 and 2018, which took the City of Cape Town with its around 4.6 million residents to the brink of a day zero. A similar historic drought emerged in Gqeberha at around the same time, but it lasted much longer. The Knysna fires in 2017 cut a path of devastation through the town, which resulted in the largest number of buildings destroyed by fire ever in South Africa, and the tragic loss of lives. In April 2022, the KZN coastal zone, including the Greater Durban area and the South Coast, received more than 300 millimeters of rain in 24 hours. This led to calamitous flooding, with 459 people losing their lives. Over 4,000 homes were destroyed, and 45,000 people were temporarily left unemployed. The cost of the infrastructure destroyed and the related business losses amounted to an estimated $2 billion. These events, aggravated by an ongoing national energy crisis, deepening urban poverty, and aging urban infrastructure, are foregrounding legally relevant questions concerning loss, damage, liability, and accountability. According to the definitions of urban law by trailblazers such as Nestor Davidson, Antonio Layard, Marius Pieterse, and Stephen Beresford, urban law encompasses different forms of authority and legal norms generated by local governments, as well as different conglomerations of multi-level public and private powers. These powers all shape urban governance structures, processes, and relationships. And when we therefore deliberate the future of urban law in South Africa, we are to bear in mind that it refers not only to statutory law reform or progressive judicial developments. It encompasses more. Yet the question for those focusing on classic local government law may justifiably be, have we not already seen enough law reform since 1996? Is the problem not that of failures of implementation and poor governance? Why bother with the future development of urban law if the heart of the problem is bad management, bankrupt state-owned enterprises, state capture, and corruption? I'm often confronted with this question and would like to argue that the intensity of the global climate crisis compels the legal fraternity to approach this narrative differently. Based on my research during the past decade, I should like to single out 6 of the many questions that challenge us to reimagine the future of urban law. The first, how to radically improve legal compliance. For a long time, I've been arguing that South Africa might not even need a Climate Change Act if only we could improve our compliance with and enforcement of the provisions of the Constitution and our extensive suite of, and I want to emphasize this, world-class statutes that carefully regulate the protection of the environment and the just energy transition. We must deeply question the persistent culture of non-compliance among private and public actors alike, and the impact this has on climate resilience. It may typically be necessary for the Auditor General to drive dedicated legal compliance audits in terms of water and waste, disaster risk reduction, and housing law. In the end, the government's non-compliance with the laws aimed at the integrity of ecosystems, the protection of infrastructure, and the promotion of human health and well-being amounts to a loss of money and the potential loss of life. Last week's terrifying building collapse in George being a very real reminder of this. And by the same token, we should be critical of repetitive, alternative compliance arrangements formally being granted to some of the biggest corporate polluters in our country. 2, what is required of municipal finance law to match the ambition reflected in climate change law and policy? To answer this question, it is necessary to consider aspects such as the fact that the own revenue base of municipalities is highly dependent on industries and infrastructure that are carbon and natural resource intensive. As you will be aware, municipalities sell water and electricity to cover their bills, and they tax properties. Often these are buildings with considerable carbon footprints or coastal properties facing severe risk of sea level rise and flooding by storm surges, as the ongoing research of the CSIR is showing. The entire post-1996 legal framework supporting municipal finance may have to be redesigned in the face of climate change and the rollout of government's new district development model for local government. For this purpose, researchers and practitioners must tap into the potential of the green and blue economies, climate finance, municipal bonds, green procurement, as well as the formation and potential of metropolitan regions in areas such as Gauteng and industrial development zones in the Eastern Cape. 3, how to drastically adapt the local governance instruments in the Constitution and existing local government legislation. A few of us working in this field have done considerable research on the topic of local governance instruments during the last few years. The way in which climate change is impacting on municipal areas suggests that the otherwise great legal design of these instruments has become outdated and suggests that the following issues require investigation. The desirability of command and control regulation through municipal bylaws and municipal courts, for example, as opposed to using financial incentives and disincentives to change behavior. The potential of law that supports e-governance and that responsibly embraces social media and novel software technologies, AI, and aspects of smart city governance to gather data, but also to communicate and govern more effectively. Conducting spatial planning based on reliable data and forecasts and aligning spatial justice imperatives with municipal integrated development plans with the protection of the community, local ecosystems, the built environment, and digital infrastructure in mind. We must critically evaluate the suitability of existing urban law instruments to judge if they take fully into account the reality of informality, structural urban poverty, and the explicit or nuanced exclusion of the needs of people in cities because of their race, their gender, their age, disability, sexual orientation, culture, language, religion, lack of home ownership, and citizenship. In other words, when a municipality adopts bylaws, policies, programs, or plans to address climate vulnerability or to limit local carbon emissions, is it aware of the potential unintended consequences of these actions and their hidden biases, including, for example, criminalizing homelessness, discriminating against small businesses, or people without access to reliable internet and data, or demolishing a family's livelihood? We must be mindful that because of climate change, it will become increasingly less clear how basic legal principles such as negligence, foreseeability, force majeure, and reasonableness will apply to particular problems. 4, how to agree to disagree, facilitating coalition governance in the face of urgency and emergency. This question is political and stems from a new era of negotiated municipal leadership. One of the real risks of coalition councils is the stifling of decision-making and municipal action, as well as decision-making and municipal action, as well as the fact that instead of having a choice between an executive mayor and an executive mayoral committee, coalition councils have but little choice to go down the latter route. Coalition councils are often unstable and terminated before the end of the council's term. Post-constitutional local government law was never designed for some of the technical intricacies arising from the plethora of coalition councils we have today. In other words, there are no rules, no guidelines for municipalities governed by a coalition. Delayed decisions and absent long-term planning could become highly problematic in the context of the urgency and unpredictability of the local causes and impacts of climate change. 5, is our public participation law advanced enough? This question commands that we pay attention to 1, the vague mandate and functions of municipal wards that are in principle ideally situated to identify neighborhood-level climate risks and vulnerabilities, and 2, the voluntariness of the advisory committees envisaged in Section 80 of the Municipal Systems Act that can assist mayors and mayoral committees with expert scientific advice on climate change. Few municipalities have functional platforms for meaningfully involving corporate stakeholders, civil society, or other community members in their strategic decision-making. We should further question the administrative law impacts and complexity around the liability and accountability of NGOs and civil rights organizations, such as Gift of the Givers and AfriForum, voluntarily stepping up when critical municipal services fail. While these philanthropic community interventions are often born out of desperation, they may not always be sustainable in the long run and could obscure state liability. 6, climate litigation is here to stay. How to ensure responsible yet creative lawyering when municipalities are involved. South Africa's Centre for Environmental Rights recently published an investigative report analysing who should be held accountable for the loss and damage that followed the 2022 floods in KZN. Less than a month ago, the Green Scorpions secured a record 150 million rand fine and criminal court conviction against a local municipality caught fouling the Vaal River, residential areas and farming land with untreated sewage flows. These developments remind us that the impacts of climate change demand the often challenging determination of causation, disentanglement of personal and corporate liability, and judicial crafting of meaningful and long-lasting remedies. Remedies that will result in outcomes aligned with the spirit of the trias politica, the separation of powers, but that do not unnecessarily add to the workload of the judiciary if one thinks of structural interdicts, for example, or that further eat into already constrained municipal budgets. It is quite possible that the courts will gradually face more requests for intergovernmental interventions of the kind provided for in the Constitution, and I further suspect that future socio-economic rights adjudication will increasingly require litigants and the courts to pay attention to subsidiary questions of climate risk and vulnerability, as well as attribution climate science. What I came to learn about our role in all of this, the role of the law professor, teaching. By its nature, mastering urban law as a subject field requires conceptual and contextual knowledge. Teaching urban law creates a wonderful opportunity to contribute to the holistic development of law students, part of which is to stimulate curiosity about the legal relevance of urban development trajectories and global climate change. Further, by using the relevant challenges and opportunities presented by urbanization, I see it as my role to assist students to identify and understand what it means to be an engaged citizen, passionate about constitutionalism, democracy, and social and environmental justice. The very emergence of the hybrid field of urban law is a testimony to the fact that law cannot be made, applied, or understood outside of the spatial and temporal social, political, and economic conditions of its production. I've always seen my students to be agents of future societal change. As a field of teaching, urban law enables a transformative student experience, considering South Africa's and Africa's urban development trajectory and how it continues to be shaped by historic and contemporary law, as well as by non-law forces such as climate change, politics, economics, and increasingly also acts of war. Postgraduate supervision and mentoring. I'm standing here tonight because of exceptional mentors, and during my career I've moved on to become a postgraduate supervisor and academic mentor who is deeply in love with this part of a professor's job. Supervision has taught me over the years that at least some students long for knowledge and understanding of issues of law and justice that are literally and figuratively close to home. Whilst I've been mentoring and supervising on research technicalities and how to frame a proper legal research question and study objectives and how to design legal methodologies suitable for a chosen topic, I have in turn learned an immense amount from my doctoral and master students about law, urban life in different contexts, and people's close religious, cultural, and other connections with nature in various parts of our country, but also in places such as Cameroon, Nigeria, Zimbabwe, Namibia, Lesotho, and Botswana. I've learned that unless we stimulate and instill academic interest in slightly less commercially sexy legal subjects at postgrad level, it will be extremely hard to raise a next generation of law scholars, academics, with a real passion for those fields and adequate knowledge of them. The committed and compassionate mentoring of postgrad students and postdoctoral researchers is a gift that keeps on giving. To academia, yes, but also to a society in need of smart, practicing lawyers, as well as critical legal thinkers and lifelong learners. Research and scientific engagement. It is research that will keep the subject field of urban law alive. It is still in its infancy in South Africa, with only a handful of scholars working in this area. There is a lot to be said about the research needed, but let me keep to three statements. One, strictly doctrinal legal analyses will not be able to do justice to the development of urban law, even if we take climate change out of the equation. Methodological pluralism and legal research infused with information collected through Empirical research, such as case studies, are vital. This admittedly requires a mindset change, also among editors of law journals, research training, and financial support. 2, the future of urban law depends on the ability to see problems through a multidisciplinary lens. In my experience, it is simply not possible to fully grasp urban law without understanding at least some of the science behind spatial planning and urban design, municipal finance, urban geography, property markets, economics, AI, the built environment, and the drivers of urban poverty, to name but a few. Researchers from different scientific backgrounds must collaborate, and deliberate efforts must be made to share the research findings with those involved with practicing or in practicing urban law. 3, there's a serious shortage of urban law research and information from the global south, Africa in particular. This creates a dangerous gap in the global knowledge base on urbanization and a body of research that informs international efforts to improve city-level energy transitions and climate justice. Urban law scholars from South Africa must progressively help expand the geography of legal knowledge in this field. And while foreign insights may lead to new explanatory legal theories, we must vigilantly guard against the global north becoming our frame of reference. The role of the broader academic fraternity, Stellenbosch University and beyond. While the field of urban law may still be a novelty at Marties, this university holds exciting potential for its future development. Urban law intersects with most of the established research expertise in this faculty. The research of scientific groups in other faculties, such as the Center for Sustainability Transitions, the Sarchi Chair in Socio-Ecological Systems and Resilience, the Trilateral Chair in Mainstreaming Gender for Energy Security in Poor Urban Environments, and the Center for Research on Democracy are regarded as world-class, whilst the possibilities are endless for the recently established School for Climate Studies under the leadership of Professor Guy Mitchley. The university may also draw lessons from the existing multidisciplinary urban study hubs at universities like WITS, UCT, University College London, the Harvard Graduate School of Design, and the University of Toronto. It's also not far-fetched to contemplate the possibility of a future 5 to 6 year BSc Science and Law qualification, and such programs have become quite popular in law schools in countries such as Australia and the United Kingdom. I am a strong proponent of interinstitutional collaboration. I believe that our resources in South Africa are too stretched not to work together towards common goals and the expansion of comparatively small legal study fields. It's therefore a wonderful privilege for me to have former environmental and urban law students and colleagues, I actually call them friends, from UCT, NWU, and UWC here in person tonight. I know that because of our shared passion, our working relationships will continue to grow and have an impact well into the future. To conclude, the role of civil society, all of us. So finally, what could the rest of us do? Individuals and families, and trying to live our best lives in the city where we decided to work, live, study, and play. Every one of us have a role to play in protecting the rule of law and in seeing urban law work equally well for everyone, despite our being different and despite the changes in the climate. 3 areas of impact stand out when I put on my shoes as a resident of this complex society are the following. We, as civil society, must constructively engage in our professional and personal spaces to identify, understand, and confront the climate risks, challenges, and opportunities we face. We must be bold in sharing visionary ideas for adaptation via the public participation processes provided for in law, especially those processes of government that concern long and short-term municipal planning, intentions to convert land use, and the annual process of municipal budgeting. We must educate ourselves and the young about narratives and conduct in our work and living environments that aggravates collective vulnerability, including lawlessness, civil disobedience, and devastating corporate activity. Where we can meaningfully assist by means of our scientific or business expertise, resources, or our time, we should. And during this time of political as well as environmental change and flux, it is all of us that must hold leadership to account, not only for municipal service delivery and being frontline defenders when weather events strike, but also for upholding the values of our Constitution and maintaining the constitutional vision of developmental local government. We must be the constant reminder of the state's duty to diligently function as the trustee of the urban commons and the various resources it holds in the proverbial public trust, for us as well as for generations of trust beneficiaries still to come. Thank you. Professor Kajika will formally conclude with a vote of thanks in a few minutes, but please allow me to say a few personal thank yous. Thank you very much, Professor Moyo, Professor Smith, and the Law Trust of this faculty for having created the space where I hope to make a meaningful contribution in the years to come. Your support is deeply appreciated. I wish to acknowledge all the academic and support staff of the Faculty of Law here at Stellenbosch who went out of their way to kindly help me settle in the past couple of months. Thank you to my doctoral supervisor, Professor Wilhelmine du Plessis, for being here in person tonight. Thank you for having been an incredible mentor and support all my career. Thank you for having come all the way from Potchefstroom with my dear former colleagues, Professor Christa Rautenbach and Professor Germarie Viljoen. 6 of my former doctoral students are here in person tonight, most of them now pursuing their own very promising academic careers, and it warms my heart to have all of you present here. To my close friends and family who traveled far, some of them very far, to Stellenbosch, I appreciate your presence and your interest more than you will ever know. And what a privilege to have my parents present here this evening. I wish to thank them for being my biggest supporters, for unknowingly having equipped me for all the demands, but also the excitement of life as an academic. When I gave my first inaugural lecture more than a decade ago, I went to bed that night in peace and quiet. I was not yet married, and motherhood was at most a distant dream. This evening, I'm blessed beyond measure to be able to thank my husband, Marius, for being an incredible and consistent support and inspiration, and to be able to tell my 4-year-old twins, Christoph and Georg, that despite the madness, your mom would never have wanted this evening to be any different. Thank you.
Thank you so much. I will have to, maybe if we can clap again. Thank you so much. And first of all, I want to obviously observe all protocols, and in particular, of course, acknowledge the Dean of the Faculty, the Vice Deans who are present, the faculty staff, the parents, the family, friends, the supervisor, and where's your husband? I didn't see where he's sitting. And the twins are not present, yeah? Are they here as well? Yeah, okay, so welcome everybody, and thank you so much. I really want to just observe your presence. I want to first of all say congratulations, of course, to Professor Anél, to Plessis for delivering the lecture successfully on divining the impact of climate change on the future of urban law in South Africa. So you have in summary shared your contribution, of course, to the research in this area that has culminated again for the second time to Stellenbosch University for recognizing your scholarship, contribution to learning, and she also spoke about the supervision, the passion you have for training the next generation of scientists, and of course contributing to learning and teaching and academic engagement at large for you to also rise at this level of full professor. So just to remember that, of course, this is the second time, and you are already a chair and full professor at Northwest University. So we thank you for really making the time, and also for choosing to join us all the way from Northwest University to be the new chair, of course, in urban law and sustainability governance at Stellenbosch University. So from today's lecture, without really going into detail about the summary, you did a very good lecture, and maybe summarizing might reduce it to missing some points, but I'll just mention a few takeaways. The issue around urbanization challenges, of course, which contribute to, and looking at the factors that contribute to the challenges that one can face. And these challenges are complex in cities where law, quasi-law, and lawlessness coverage, service delivery, and economic development and the impact on women and health also come into play. And then the work that she has done over time also contributes to, I think, all the sustainable development goals. There are 17 of them, but she focused on SDG 11 and 13, the two sustainable development goals. But if you look at the work, the coverage, it covers all the sustainable development goals. And also, I think the importance of city dynamics. So urban areas are obviously marked by conflicts of rights governed by politics, trade, and investment than democratic order, and influenced by property, ownership, wealth, and access to information and technology. And I also take it that this lecture, actually, the timing is good because May is an election month. And I think it's important for us to also think about how we take make people accountable, for what they do in terms of the leadership, the governance that they use to govern our cities, and what's happening to us in terms of the well-being of people generally. And then you also touched, of course, on the nature of urban law. So urban law in South Africa is a complex mix of private, public, and mercantile law with diverse sources of authority. When I was walking in today, some of the colleagues outside were telling me that, so I say to them, because my background is maths, but they said to me, we can teach you law 101, and they told me that I just need to remember two things about law. I think it was the private law, that private law was more important, and then I also should remember that after that. And then they told me that I should also remember only two things, private law and contract law. So I thought, okay, but this lecture obviously has proved beyond that. Some people are agreeing, but of course, you have opened, of course, my world to urban law, which I wouldn't have known about if I just stood outside with my two colleagues. So, yeah. So also the issue around, I think one of the other points I got was around legal geography. So urban law, of course, shapes justice trajectories and plays a crucial role in court decisions involving various municipalities. But of course, I think we have the chair here for social justice, Professor Madonsela, who's here, whom I believe you've met, Tudi Madonsela as well. And we were just talking about issues also around social justice and what it really means. And you know the challenges we have now as a university, I mean, we are also looking at, how to deal with conflict when you look at what's happening in Palestine, Israel, and other parts of the world where there's conflict and how we respond to it. So, and then I think the other thing that which I picked up was around future implications. So, of course, the lecture explores how climate change and resilient development will influence the future of urban law in South Africa, but how it also impacts on legal practice, research, and teaching, and the importance for us to make sure that we also grow our research enterprise, that we contribute to skills training in this area, because we believe that as you have indicated, that the intersection between not just law itself, urban law, but also climate change can give students a transformative student experience in terms of what they can take away and how they can contribute, I guess, also to influencing policy, influencing some of the practices that we do so that we can create a resilient and sustainable future for everybody. But the one thing which I think I should take away also for, especially around research, is the issue around, the importance of postgraduate mentorship, which we believe, which you have shown. And I think with the deans, we've been discussing the need to double the PhDs. So I was so glad to see the passion we have. And I thought sitting next to the dean that, oh my God, so we can double the numbers for the law faculty in the next few years as well. And then the other part, of course, is on research and scientific research and its importance, of course. You mentioned that. And then, of course, the intersections, I think the possibility of having degrees which intersect both the law part and also the science part. You talked about the BSc in science and law, not for 6 years, but maybe 5 years. But I think it sounds good to think about that as well. It's a potential area. And I know that as a faculty, there have been already discussions around, trying to have these interdisciplinary courses as well. So I just want to thank you for your lecture again, and also thank you for being here, and we look forward to the future and wish you the best while you're at the university, and hope that, I guess this is the last lecture, so you can sleep today. And maybe in the next life you won't want to do another full lecture as well, but thank you so much once again. Thank you. Thank you. So I think now it will be time to acknowledge the rest of the people who contributed, but in general, I'll just thank everybody else who has contributed to this lecture, and my colleagues who will just come over to do the rest of the vote of thanks. So can I ask my colleague to come through? Thank you.
Before I convey Anél's gratitude to the persons without whose assistance and support this evening would not have been possible, I would just like to abuse the mic and congratulate you, Anél. Well done, and very interesting. I cannot work in so many areas of the law, I must admit. The DVC, Professor Moyo clearly bumped into Professor Jacques du Plessis before today's function. Everything is applied contract law, apparently. But let me convey Anél's gratitude. First, and in no particular order, but so any omissions or ordering is due to my ineptitude. But first, I have here the Law Trust, who has made this appointment possible, and of course the establishment of this chair in, as you will have gathered, a very important area of law, a very complex area of law, lots of moving parts, and we are really pleased that Anél decided to join us. Then we want to thank the Stellenbosch University and Faculty of Law staff responsible for the logistics around this event, particularly Jonathan Dale Blankenberg, Cindy Arendse, and from our own faculty, Yolandi Philander. She'd also like to thank Nicola for generous financial support for the event. I want to find out about the finances a little later, but clearly there's some slush fund here. But thanks, Nicola. And thanks to our past staff who play an incredibly important role in the background. Of course, key amongst these people are Gerda and Kathy. And of course, thank you for taking the time to be in attendance and making a success of this function. Some of you have traveled from other parts of South Africa, Potchefstroom, Johannesburg, Cape Town, Vanderbijlpark. So thank you for making the effort. And we do have an online audience, and I must thank those of you who are attending online for, again, taking the time to sign in and listen to this lecture. And all that remains for me to do is to tell you, for those who are present here, and if you're online, if you can hurry, there are some snacks in the quad. You're welcome to join us too. Thanks.
Thank you. Can you please rise as the procession will leave the venue now? Thank you.